Hello, my name is Galyna Pribytkova. I am a lawyer in Mississauga, Ontario. I practice in areas of family law and civil litigation. Today I would like to tell you about marriage agreements. Why do we need marriage agreements, and why is it important to hire a lawyer to prepare a marriage agreement? Sometimes my clients ask me, well, why can't we do it just ourselves? Why can't we just download it from internet and just sign it in front of a witness without a lawyer being involved? And my response to this question is this, that yes, we can do it. If two parties sign a marriage agreement without involvement of a lawyer, it does not become automatically invalid. No, it is valid until it's proven that it's invalid in court. And still, of course, every lawyer's advice is you need a lawyer to prepare a marriage agreement. And there's some information that clients may not be aware of, and some legal issues that they may not know, and that's why it would not be addressed in a marriage agreement when it's prepared by clients. When do we prepare marriage agreements? Usually they are done in anticipation of marriage, or sometimes even after the marriage has already been formalized. When a client comes to my office and asks to prepare the marriage agreement, the first and foremost that I ask my client to do is provide me with financial disclosure. This financial disclosure is absolutely critical in preparation of any agreement: marriage agreement, separation agreement, cohabitation agreement, any family agreements that we prepare as lawyers. In Ontario, Canada, usually, well, how it works is that we have a Family Law Act which governs the property regime upon the parties' separation, divorce, or death of either party. And why marriage agreements are important in our legal system is usually to protect property rights and sometimes support obligations. So what is usually set out in the marriage agreements? Usually it's property regime, so distribution of assets, property regime during marriage, and sometimes support obligations upon the parties' separation, divorce, or if one of the parties die. Section 5 of the Family Law Act allows a party to a marriage claim equalization. What it means is that that party may apply to court and ask that the net family properties of both parties to be equalized, which means that the party with lesser net family property will receive 1/2 of the difference between the party with lesser net family property and the party with a bigger net family property. What is net family property? And I promise you it's really relevant to marriage agreements, this legal discussion. What is net family property? It's defined in Section 4 of the Family Law Act. Net family property is the value of all property that a party owns on a separation date, excluding the excluded property, and there is a list of excluded property, what constitutes excluded property. After deducting the parties' liabilities on the date of separation, and after deducting the net marriage date assets other than the matrimonial home. So what it means in lay terms is that whatever you owned on the date of marriage, and I'm talking net assets, will, other than the matrimonial home, will be deducted from your net family property, which means all of your assets other than the matrimonial home are protected by operation of Section 4 and 5 of the Family Law Act. Why the matrimonial home is treated differently? Well, first of all, matrimonial home is the home where you intend to reside with your married spouse, or you already reside with your married spouse. Why is it treated differently? Well, it's just our legal system basically protects the rights of married spouses the party which does not own the matrimonial home, and in order to have equitable remedies upon the divorce or separation, and to equalize the assets at the separation date. Therefore, just protecting the rights of non-owner, the non-owning party of the matrimonial home. So if a party brings a home into the marriage, a mortgage-free home, or where there is substantial equity in the matrimonial home, usually that's when that party seeks the protection by way of the marriage agreement. If a party enters the marriage, brings the home into the marriage, and there is no marriage agreement, again, under section 4 and 5, that matrimonial home will be equalized in accordance with the law. I always encourage my clients to print out all of the bank statements, all of the investment statements, they will have to be able to prove all of the assets they owned as of the date of marriage. The marriage may last 15, 20, 25 years, and bank statements may not be available at that time later on. So I always advise them, please print out all of the bank statements, investment statements, whatever you have. Please document whatever you have, because those assets will be deducted from the net family property, except matrimonial home. And let's not forget that there may be more than one home be considered matrimonial home. The matrimonial home, again, we have definition. It's basically where the married parties reside at the date of separation, and they may reside equally in a house here in Mississauga, and they also have a cottage where they reside 5 to 6 months per year. So the court may find two residences being a matrimonial home, and that's why it is important to protect it if a party brought it into the marriage. So the information I'm providing you is just the general information only. It's not intended to be legal advice, simply because there are many scenarios, many factors that may impact the information I provide to you one way or the other. So I just be aware of that these are just this is just general information. So when my clients come and I start to come to my office for help, I ask them to provide financial disclosure, and this financial disclosure will be provided to opposing party or his or her lawyer, if we know the lawyer at that time. Usually it's done by the way of Form 13 or Form 13.1. These are forms of the family law rules, and all the assets and liabilities are disclosed as of the date of marriage, or as of now if the marriage has been already formalized. Basically, as much financial disclosure as possible. I mean, sometimes my clients say that they don't want to disclose something, and I'm just advising them that there are risks if you don't disclose your assets or liabilities before you prepare an agreement. It's what risks I am talking about is that if a party does not provide a financial disclosure, the agreement may be challenged in court. The agreement may always be challenged in court, but the fact whether it's going to be set aside or not, that's a different story. So what I'm telling my clients, that if you don't want to disclose your assets or liabilities, it may be detrimental to you later on, and that this is the risk you're taking. And I'm strongly encouraging my clients to disclose everything, just in order to protect themselves. That's in the first place, they're protecting themselves when they make full financial disclosure. Another issue is I always encourage the opposing party to seek legal advice before signing the marriage agreement. Sometimes I see a signature of that opposing party being notarized. Basically, it says there's a stamp saying signature notarized, but no legal advice is given. And the value of that is basically not much. The value of that notarization is not much because there is no legal advice that was given to the party. And what is the most valuable part of signing an agreement with a lawyer is the legal advice. Again, I warn my clients that if the opposing party, signs a marriage agreement or any agreement without legal advice, there is a possibility that that agreement may be set, or in whole or in part may be set aside by the court later on. My client sometimes may say, well, if she goes to a lawyer, the lawyer will advise her that this, and that, and then I will be disadvantaged. And I'm saying, no. We want her to know all of her rights and obligations before she signs the agreement, because if she does, this means that the agreement has been entered with both parties being fully advised of their rights and obligations, and they made conscious choice with respect to what they wanted to set out in that agreement. If the agreement is challenged in court, there are several bases that the agreement may be challenged on. So lack of financial disclosure, lack of legal advice. Sometimes the parties say, well, I did not understand what I was signing, or I didn't understand English. The court has discretion to set the agreement aside or set some provisions of the agreement aside, and it's just the court looks at all of the circumstances at the time the agreement was signed. Well, first of all, of course, it's the level of sophistication of the party challenging the agreement. For instance, as an example, if the opposing party is a legal assistant in the law office versus some construction worker who doesn't speak English, of course, the court will look at the legal secretary as basically will place a high burden of proving that she did not understand what she was signing, or that she didn't understand the importance of obtaining legal advice. So the burden will be higher, so the threshold will be higher on legal assistant versus the construction worker who doesn't speak English. So in addition, the court will look at how fair the agreement was at the time it was signed. Again, many factors play role in this finding of the court, and the more unfair the agreement was to the challenging party, and if that agreement has deficiencies such as lack of legal advice or lack of financial disclosure, the more chances that the agreement will be set aside. So that's why I always advise my clients full financial disclosure and legal advice. Those are the two most important prerequisites of signing a valid marriage agreement. Thank you.